Good morning, everyone. This is the stakeholder meeting to discuss the Office of Consumer Credit Commissioner's Pawnshop Rule Review Amendments. My name is Matt Nance, and I'm the OCCC's Deputy General Counsel. I'm joined by a few members of the OCCC staff, including Compliance Coordinator Kimberly Bio, Assistant General Counsel Lori Hobbs, Commissioner Leslie Pettyjohn, and our Director of Consumer Protection, Rudy Aguilar. In the audience are General Counsel Michael Rigby, Assistant General Counsel Alexandra Gullett, Manager of Licensing Moran Zepeda, and Senior Review Examiner William Purse. At the entrance of the room, we have copies of our stakeholder meeting notice, which includes a copy of the rule amendments. A copy of the meeting notice is also available on the OCCC's webpage for recent and upcoming rules. Also at the entrance table, we have a sign-in sheet. If you are not currently on our email stakeholder list, please provide your name and email address so that you'll receive any rulemaking notices for pawnbrokers in the future. We're holding this meeting on GoToWebinar. Some of you might be listening on your phone, some may be watching on your computer, some may be doing both. For those watching on your computer, there's a window where you can submit questions. If you have technical questions about using the webinar, you can type them in there and Kimberly will try to answer those. If you have any questions or comments, go ahead and type those in at any time and we'll be getting to those. And if you're on a computer with a mic, there's a function allowing you to raise your hand, and then we can let you make a comment verbally. For those of you here in person, you can share your comments or questions from your seat, town hall style, but keep in mind that if you do that, we will need to repeat the comment so that those listening online can hear it. And with that, I'll turn things over to the Commissioner.
Okay, thank you, Matt. First of all, I just want to say welcome to everyone, both here in the room and those who have joined us online in our online community. Thank you for coming to the meeting. We are very grateful for your participation and attendance today. We don't take up rule review lightly. We take on rule review. It's required of us every 4 years, and it's important that we make sure that our rules remain relevant and that we try to deal with outdated provisions and to keep them updated as best we can. Getting input towards that process is very important. We start with it, we go through this process in a way where we really encourage participation from interested stakeholders, and we have many opportunities for stakeholders to provide us with that input, but the participation is very important towards us getting a good draft to proceed with and to recommend to the Finance Commission for their proposal for official comment and review. The goal here for all of us is to make sure that we get the best product that works for all parties that must obviously comply with or use the Texas Pawnshop Act. So with those little introductory remarks, again, thank you all for being here. I'm very interested in what comments folks have to offer. With that, I'll turn it over to Laurie to give an overview of the rule review and the process and these particular amendments.
Okay, well, again, good morning, everyone. My name is Lori Hobbs, and I'm one of the attorneys that drafts rule amendments for the agency. And as you know, I'm also the rules liaison for the OCCC and sending all the communications when we're doing rule reviews and other amendments. We're organizing the meeting in three major parts. Part one, where we are now, is just an overview of the rule review process and the purposes of the amendments. Part two, I will do a division by division breakdown of the rule changes. And part three, we will have some time for additional questions and comments that stakeholders may have that were not previously addressed during the meeting. First, I'll just say a little bit about the process and timeline for these rules. As the Commissioner noted, the government code requires state agencies to review their rules every 4 years to make sure they should still exist and to do any necessary updates. And this is, again, this process is rule review, and that's what these amendments are coming out of. As far as the timeline for these particular rules, we are accepting informal written pre-comments until 5 p.m. tomorrow. We call those pre-comments because we accept them before the official comment period that is anticipated later. And you can email those pre-comments to rule.comments@occc.texas.gov. We plan to propose these rules at the Finance Commission's October 19th meeting, Commission will vote whether to publish them for comment. There will be time where you, assuming all goes as they do publish, there would be time for the official comment period during November, and then according to schedule, the rules will be up for adoption at the Finance Commission December 14th, and be effective early next year. Next, I just wanted to briefly go over the rules purposes. As provided in the meeting notice, the purposes of these rule amendments are to ensure consistency with current licensing terminology, agency procedures, and streamline processes, to modernize or remove obsolete language, and make technical corrections as well. So just on the process and the purposes, do we have any questions so far? Any questions online? Okay. Well, then I will move to part 2 and begin our breakdown and discussion of the rule amendments division by division. So I'm going to go through the pre-comment draft in rule number order, describing the changes in each division of the rules, and I'll pause for questions periodically after groups of divisions, and then again we'll have an opportunity for questions and comments after reviewing all of the amendments. So in this first section is Division 2 for Pawnshop license, and I've actually divided the discussion of this into 2 segments. The first part is going to focus on Pawnshop applications, and the second will focus on application processing. In this first segment in Division 2, there are some updates regarding licensing terminology to 3 types of our rules regarding Pawnshop license applications. So beginning on page 1 of the pre-comment draft, the rule changes to ensure there's consistency with current agency procedures are in 85202 concerning filing of new application, 85203 concerning relocation, and 85205 concerning transfer of license, new license application on transfer of ownership. So in more detail, beginning on page 1, the changes to 85202 begin with the use of the agency's acronym, OCCC, where it's more appropriate to refer to agency action as opposed to the commissioner specifically. On pages 1 continuing on through page 2 in 85202 1A and 1B, we're streamlining the introductory wording and grammar to more closely track the online portal and to no longer refer to specific titles used on paper licensing forms. Additionally, there are changes to 85202 1A III involve the deletion of unnecessary language. This will allow for electronic signature of an authorized individual of the applicant without reference to particular titles of the person signing. On page 2, we're amending 85202 1D in 3 ways, and these are similar to changes approved by the Finance Commission in some of our other regulated areas. First, the term registered agent would replace statutory agent. These terms, we've used them synonymously, but registered agent is used by the Secretary of State and has become a more common term. A natural person now requires simply a different address from the license location, as opposed to the outdated requirement of a physical residential address. And a company secretary may submit certification identifying an agent if that differs from Secretary of State filing. There are several changes continuing on pages 2 through 4 with updates to licensing terminology. One particular item I wanted to point out toward the top of page 3, you'll see an amendment to 85202 1I regarding bank confirmations. This update memorializes the long-standing OCCC licensing procedure to obtain bank confirmations if necessary. Moving on toward the bottom of page 4, we're updating 85202 2A IV regarding fingerprinting. These amendments correspond to changes approved by the Finance Commission in the OCCC's other licensed areas and provide increased flexibility so that applicants will not need to resubmit if acceptable prints are on file. The remaining changes on page 5, continuing through most of page 6, relate to updating the entity documents required for new applications. These changes align the rule with the online portal, listing the required documents first, removing documents no longer required, and listing last documents to only be provided if requested by the agency. Moving on to the top of page 7 in 85203 concerning relocation, the changes to this rule continue the use of the agency's acronym and updates to licensing terminology. And on page 8, the changes to 85205E4 concerning transfer of license, new license application on transfer of ownership. These changes provide corresponding revisions to licensing terminology. So a lot of those are really pretty straightforward technical corrections. Do we have any questions on this first segment of Division 2? Anything online?
I guess it is under the fingerprint section, removal IV, where you state for 10 years, we have it on file for 10 years. It looks like it says we shouldn't have to resubmit it, but the word generally is inserted, and it seems to make it not something that we can rely on. What is the reason for the word generally as a modifier on the rest of that paragraph?
Well, I think sometimes it can deal with perhaps the quality of the fingerprints that we have, and sometimes there might have been some that were filed that may have been done through a different procedure. So I believe that was.
I understand when we're changing this, so used to they were not required. Now, if they're more than 10 years old and not haven't been investigated, we should have to refile, but then we generally kind of leave it up in the air.
I'm Miranda Zeta, I'm the licensing manager. So we currently go through a process with the DPS where we unsubscribe to criminal history information upon cancellation of a license, whether that's the Pawnshop or pawn employee. So if we unsubscribe to that information, we would need to then get fingerprints again and then subscribe through receiving those fingerprint instructions. Is that answer your question at all?
I guess I thought the purpose was to make this objective. It seems like it's not now. It's it might be a little bit generally.
It's the general rule, but there are some exceptions that happen based upon some of these criteria, which we didn't want to. I guess the current thinking is you don't want to have to spell every single one of those criteria out in the rule. But we can have further conversation about that and try to articulate that better.
And I don't know if I understand that perhaps with Miranda, our licensing manager, I don't know if our online folks, I guess, could not hear the explanation.
Yeah, they could, but not super well. So if you're going to talk, you may have to either be really loud or
come forward to the front row
or a little bit.
Okay, yeah, so I don't know if I can restate.
We heard him okay, but yeah.
The explanation for those listening online was that we may unsubscribe to the normal subscription from the Department of Public Safety that processes the fingerprints, in which case we would need to then request a new set of fingerprints be provided through DPS's system. Did I repeat that correctly, Moran?
Yes.
Okay.
All right. So, another question?
Next page. Page 5.
Okay. Well, I think I'm going to be talking about some of the. And maybe we've already gone over that.
This
on the entity documents.
Yeah, the corporate documents.
Yes.
Roman numeral 2, and specifically 2, but the 3 as well, provides that we have to be in compliance with the Secretary of State and have everybody named, et cetera, and we have to submit that. Then down in Roman numeral 5 and 6, it states that if requested, we would have to provide additional corporate documents that would verify what is contained in Roman numeral 2. Why would that be necessary?
think,
So the bylaws are explicitly stated in 5, I believe. Typically, we can get all the information we need in Roman numerals 2 and 3. It is rare that we would request items in 5 and 6.
If there are particular conflicts or things we may need to evaluate, but the current provision, the current regulation requires those documents in 5 and 6. So we're moving them from required to if requested basis.
I was just wondering why it wouldn't say if we didn't have the certification, we might request the documents down below.
Yeah, well, no, there are particular situations that's rare, but if we have the certification, we are accepting that in lieu of providing the actual document from the Secretary of State. But if sometimes it's rare, but sometimes there are issues that information's in conflict and we are having trouble ascertaining who the relevant directors and officers are, and we may need to ask for a physical copy of that document. So.
okay. Any other questions? All right, well, I think we will move on to the next group of rules. These are continuing on in Division 2 with the second group of rules that relate more to application processing, and we'll also discuss some similar amendments in Division 3 for pawn employees. So on pages 8 through 9 in Rule 85-206 concerning processing of application, we're amending this rule in 4 ways. First, we're removing some acceptance terminology. We are adding email delivery for notice of competing application and protest procedures. We have continued use of the agency's acronyms and an updated reference to the criminal history rule 85601, which was recently consolidated from 2 rules into 1. Next, I'll outline some additional details on those first 2 changes in 85-206. First, in 85-206A and B on page 8, the current terminology related to acceptance of a license application was intended to address paper applications that didn't contain enough information to trigger initial processing. With the online portal, the majority of pawnshop license applications are submitted electronically, and there is no longer a need to distinguish application acceptance as opposed to completion. The amended terminology will focus on completion as built into the online portal to improve the efficiency of application processing. And second, at the bottom of page 8 and continuing on page 9, the changes to 85-206E, these will enhance the OCCC's ability to more quickly deliver the required notice of application and protest procedures when a competing application has been filed in an existing pawnshop county. Section 371.057 of the Texas Finance Code requires that such notices be given to existing pawnshops when a competing application is filed. New paragraphs 1 and 2 in subsection E will allow the OCCC to email the notice of application and protest procedures to the master file email address on file. If the email is not deliverable or if an existing licensee does not have a master file email address, then the notice will be sent by mail. On page 10, the remaining amendments in Division 2 make the following technical corrections. There's an update to an internal reference in 85-211 concerning fees, and we're also correcting the agency name for the Texas State Library and Archives Commission in 85-212 concerning application and notices as public records. So moving on to Division 3, Pawnshop Employee License. This division contains 3 rules of changes for pawn employees parallel to the changes we've already discussed for pawnshop. At the bottom of page 10 in 85-301 concerning filing of application, the changes further use the agency's acronym along with some other terminology updates. Toward the bottom of page 11, 85-304 concerning processing of application, this section includes the type of changes we just discussed in the corresponding rules for pawnshops, 85-206. And in 85-307, the reference to the Texas State Library and Archives Commission is also being corrected in the pawn employee rule as in the Pawnshop rule 85-12. Do we have any questions on this second segment of Division 2 on processing or on Division 3? Anything online? Forgetting my stakeholder comment slide. Okay. I guess we will move on to the next group of rules in Divisions 4 and 5. These begin at the bottom of page 12. There's a few changes in these rules to enhance record keeping and reporting for licensees, along with a citation update. The first change in Division 4 concerning operation of pawn shops appears at the top of page 13 in 85402C concerning record keeping. We're streamlining the compliance file requirements to align with examinations issued through the online portal. We're also removing the requirement to maintain compliance bulletins, as those are now posted on the OCCC's website. Also on page 13 in 85405A6A concerning pawn transactions, we're updating a citation to the Texas Business and Commerce Code. This section was actually redesignated by the 2017 legislature and moved to a different section number. At the top of page 14 in 85421 concerning consumer information, this section is being modernized. While the pawn shops may request additional copies of the consumer brochures from the agency, this amendment clarifies that licensees may print additional copies of these brochures as available on the OCCC's website. The loan rule change in Division 5 concerning inspections and examinations is in 85202, and this updates the annual reporting rule with current agency procedures. So you'll see this update in the middle of page 14. Again, this is the annual report rule, and we're aligning this reporting rule with changes already approved by the Finance Commission in the agency's other reporting rules. It streamlines the language to more simply state compliance with published instructions. Additionally, the July 31st due date for pawn shop annual reports will be added to the introductory paragraph. All of our other licensees with reporting requirements have their due date in the rule, and we think that's a good reference for you to have specifically in the regulations. So do we have any questions regarding Divisions 4 and 5? Okay, so I guess we will move on to our last two divisions in Division 6 and 7 that begin toward the bottom of page 14. These changes provide clarity and reduce regulatory burden regarding agency enforcement actions authorized by the Texas Finance Code. The first change in Division 6 concerning license revocation, suspension, and surrender appears at the top of page 15. In 85601 concerning denial, suspension, and revocation based on criminal history, subsection D2 simply contains a citation correction. The next rule, 85603, concerning reinstatement of an expired pawn shop license, includes changes to update terminology. And then on pages 15 through 16, 85604, concerning revocation or suspension of a pawn shop license or pawn shop employee license, we're amending this rule in three ways. There are updates to agency enforcement procedures and terminology, continued use of the agency's acronym, and an update to an ATF form number in subsection B4. In general, the agency is moving away from an approach where every violation results in an immediate administrative penalty. Once a violation is referred to the legal department, the agency's first response is usually an injunction with no penalty. Thus, throughout 85604, you will see these two injunctions. Then the next response is often an administrative penalty. An enforcement action may progress to possible revocation after multiple administrative penalties are received by a licensee. Moving on to 85606 on page 17 concerning surrender of license. Changes to subsection B update terminology by replacing the term administrative action with the term enforcement action. The term enforcement action is intended to avoid confusion with the more specific term administrative penalty. And then there are corresponding changes related to agency enforcement procedures included in Division 7 concerning enforcement and penalties. The two effective rules relate to specific types of violations. In 85701 concerning failure to timely file a pawnshop employee application, and 85702, I think it's 702, not 703. Apologize if I have. Concerning except prohibited merchandise. The changes to both of these rules are consistent with those outlined in the discussion of 85604. Again, typically the agency's enforcement procedure progresses through the following steps: injunction, administrative penalty, and then possible suspension or revocation. Do we have any questions or comments on Division 6 and 7?
On 6 and 7, we're taking out all the descriptions of what we do, and we're just leaving the injunction, administrative penalty, suspension of license, and revocation. It's rather vague on this. Before, we've got pretty much like, just use the licensing one, for example. You know, if they're like, you know, they're going to get a suspension. Now, we don't know what they're going to get. Are they just not going to get a license? Like an employee's license? Are they just not going to be accepted because they were late? And so there's nothing set forth.
Come sit up here, Maria.
Miranda Debate, our licensing manager.
Hi, how are you? So no, a license will not be denied simply because it is late. We will typically refer it to legal if we receive that application outside of the 75 days prior. We will refer that to legal, and I'll let them speak to that process from there. Does that answer your question?
I mean, no, not really.
Okay.
We're still just really vague as to what's going to happen. And then we go down with the acceptance of goods also. It's just vague. It just says injunction, administrative penalty, whereas before we've had it all spelled out.
Is our General Counsel, Michael Rigby.
How you doing? Michael Rigby, General Counsel for the Office of Consumer Credit Commissioner. Yes, I understand your concern. We talked about this when we were coming up with the draft, that we were reducing the language. This is consistent with our current approach towards enforcement actions in general, that our first choice is typically an injunction. So, for example, if a pawnshop employee was working without filing an application more than 75 days, then that would be referred to legal from licensing to license department to legal, and we would typically issue an injunction. If there were an injunction previously issued against that employee, then they would be in violation of the previous injunction, and we would typically assess an administrative penalty. Does that help you? Sure. An injunction is an order issued by the commissioner that directs the person to take some action and restrain. So typically in this case, it would be, you know, if you're employed by a pawn shop, you want to make sure that you file your application within 75 days to take that action and avoid violating the statutory requirement, which requires the filing. Does that make sense? Does that answer your question?
That makes a little more sense. Yeah.
Can you talk a little bit about the administrative penalty process if they've violated the injunction?
Yeah. So again, if there is an injunction in place and a person or business violates that injunction, then we typically recommend assessment of an administrative penalty, and those are commensurate, and we try to equally apply those.
Informal, they have consistent standards for if it's this kind of violation, this kind of penalty may be appropriate. Depends on some of the factors, but there's a formula associated with the factors involved.
Again, the exceptions are good. It's the same, laid out the same way. So now what we're saying, instead of going straight to penalty, we will have an injunction probably first, then go to the penalties, even though they're not set out, but they'll basically stay the same.
The injunction's gonna have specifics in it, about, in terms of, about those specific facts in that situation, what we're telling you to do or not to will be in the injunction.
Yeah, that's our typical approach. The idea is, and there are opportunities, like with the situation of acceptance of stolen goods, there is an examination process. There's typically, several conversations that take place before something gets referred to legal. Most of the time, those kinds of issues would get resolved through the examination process and exam directive. But in some cases where there's been a pattern of violations or the violations themselves are serious, the exam department may refer that issue to the legal department for issuance of an injunction. If it's extremely serious, and this rarely happens, that there's, a very serious situation, we could move more directly to some kind of reputation action if there were criminal conduct involved or pattern of violation, which occurred over several years. Does that answer y'all's question?
I think, hearing this today, if it's not really spelled out first, we have an injunction, then we move on to administrative.
And
the
we
way
can-
it reads is, any of these three things can happen after the first violation.
We can certainly work on the language and try to clarify that.
But we have a responsibility to be consistent in the way we move forward in supervisory enforcement action. So what Michael's saying is this path we're going to take. There'll be an injunction that will tell you to do something or not do something. So if you do that, you're okay. You violate that again, then you go on.
And from what I understand, like for example, the acceptance of goods, there's even more steps because there's the compliance. I mean, the exam.
Exam.
There may be a directive there that doesn't involve an injunction.
Doesn't involve
That's correct.
Correct.
Okay.
It often occurs when someone ignores the examination instructions, and that's when we get into some of these.
Well, and we're sort of taking on some language that's really, that exists on a national level. Our examination activities are really supervisory activities where we go and do that sampling, we find something, we give the instruction, correct it. That's really us acting as a supervisory function. If we have to go beyond that, then we're talking about, the enforcement action that we're looking at here with the first step being that injunction.
Right, and that was one of the comments that were made to us, that was, that she said supervisor, we didn't know if we were going strictly from a commission that is there to help to one that's just strictly there to, okay, let's stick a fine here or there. That's what it was kind of.
Right, and so the other point I'll make right now is our examination process is confidential, and in that we're normally talking with you to settle something and get something corrected, and that's confidential in the exam process. Once we get to these actions that we're talking about here in our legal staff, those. If you go back to page 15, the revocation or suspension, the first thing listed is the revoker's suspended license, almost backwards.
Yeah.
Later on, but a little confusing.
Yeah,
It is. Yeah, I think the reason we did that is because when we're changing or amending these rules, we try to keep the current language, and it just so happens that the current language was the revocation first. I understand why that caused confusion, and I looked at it the same way and had the same concern as you did. If you think other folks in the pawn industry would have similar confusion, we can consider reordering those.
Well, it would match up with what you have on the
Exactly. Yeah.
Right.
next revision.
Right. Yeah,
And I would follow up with your comments. There are, our primary goal in all of this, whether it's the licensing or exam or legal function, is to get compliance with the law. That's our goal. And we take, commensurate steps along the way to get that compliance and have conversations with y'all to ensure that you understand the law and that you're, where those boundaries are and are able to comply. And only in the case where, those conversations have failed as a result of referral to legal issuing
acceptance of prohibited merchandise. Are the administrative penalties still going to be $100 for the first violation, $200 for the second, or are administrative penalties now going to be whatever we decide they need to do based on the severity of the?
They're not going to be 100 and 200. It's not an effective use of legal resources to do an administrative penalty of $100. Rarely is it. If it's reason we do an injunction, there's no penalty.
Right.
You know, previously we would have just sent out a $100 injunction, $100 administrative penalty, and
Right.
now the first one is like zero because it's just,
So those numbers are effectively gone based on the new process.
right.
Okay.
But and I can't tell you off the top of my head what the new numbers are. I mean, they're not crazy wild, but there will be a new set of numbers, and some criteria may relate to severity, pattern of practice, some of those kind of issues that we'll be looking at. How many times have they violated prior orders? How many times maybe have they been cited in prior examinations? But there's a methodology that's approached with those.
Will that methodology be made publicly available?
It can be.
And last question, well, not last question, I've got an injunction is an order. So that becomes reportable in subsequent applications and application strategies.
Yep. Yes.
But there's plenty of opportunity to have discussions before we get to that.
Absolutely, whether it's an investigation or an examination, if we deal with it in the confines of those two activities, no confidence.
And Rob was asking about kind of the factors that go into assessing an administrative penalty. I just wanted to point out section 14.252 of the Finance Code outlines the factors that the commissioner considers in determining the amount of the penalty. Those include the seriousness of the violation, the extent of actual or potential harm to a third party, the history of violations, the amount necessary to deter future violations, efforts to correct the violation. So those are kind of the factors we're looking at.
We can refer clients, compliance, and legal people back to the statute as opposed to when they ask if they're going to be
Yeah. So look at those factors.
Well, and the best advice would be to comply with any injunction issued, I think.
That's always.
You know, before we were using 100, 200, and 500 before, you know, the employee was getting $50, $50 one. Is that considered one penalty, or is that each one going to be considered, you know, are they going to address them as two penalties? You know, that could involve the cost. You know.
Do you have what, Michael?
Well, there's, I mean, things are a little bit in flux with the sunset recommendation to eliminate Pawnshop employee licensing. And so currently, under the current law, there is joint responsibility, there's a duty on behalf of the Pawnshop and the Pawnshop employee to comply with the law. The sunset recommendation contemplates a shift away from the licensing of the Pawnshop employees and a responsibility being acknowledged by the Pawnshop itself for monitoring compliance with the law by its employees and agents. And so that's consistent with our approach here in making amendments to the rules. Again, once there's an injunction against any entity, whether that's a Pawnshop employee or a Pawnshop, and there's a violation of that injunction, the next step is typically to assess an administrative penalty, incorporating the standards, the statutory standards that does that help?
Okay. So do we have any additional questions that had not been discussed previously.
Anything from our online community?
Yep. Okay.
One more quick thing. Since you brought that up, when you say a shift away from focusing on employee licensing, does that mean like doing away with employee licensing?
That's my understanding is that
That's the current recommendation that came out with the report.
From the Sunset Commission,
Can I
Advisory Commission.
real quick? I'm sorry, they're having a hard time hearing people in the audience, so maybe we could
Restate, okay.
Yeah.
So the question, I'll restate the question, is related to the shift that was discussed to responsibility to the pawn shop and perhaps away from the pawn shop employee. The Sunset Advisory Commission, in reviewing our agency, came out with a report in April. One of the recommendations was to eliminate the licensing of pawn shop employees. They held their hearing in May. They made a decision at the end of August that would bring that recommendation forward in the form of in legislation. So there will be legislation introduced next spring that will propose to eliminate employee licensing. And so we'll see what the legislature, if they determine to enact that. And if so, we'll have to make provisions to remove that licensing, and definitely the responsibility will shift. Well, I mean, there's always joint responsibility currently between the pawn shop and the pawn shop employee, but then the shop will bear all of the responsibility in the new environment, if that's indeed what the legislature goes forward to adopt. So we're sort of in a position recognizing that this legislation is going to be introduced, and so we're trying to ensure that we are appropriate, again, recognizing the joint responsibility, but also preparing if that does come to be enacted, that we're prepared to move ahead. And obviously, we'll have to make rule adjustments. If that legislation passes, we'll be making rule adjustments next summer to incorporate any legislation that's adopted.
Some of the stuff we just reviewed, in the way it's written, it talks about suspension or revocation of, the pawnbroker license or the employee license. And obviously, if this comes to be, that will have to be amended to fit the situation. Well, I mean, part of the logic here, and the commissioner already said it, is ultimately the pawnbroker is responsible, and the commissioner felt it was presented.
And I guess I just would point out that in the current law, employers are generally responsible for the actions of their employees.
Okay. Any other questions or online questions?
Is that Sunset Advisory Commission report available online?
Yes.
It is.
Where is that?
It's at sunset.texas.gov, and they'll have a link that'll be agencies under review or current review. And if you click on that link, you'll see Office of Consumer Credit Commissioner, and you can click on our link, and all the documents associated with our review are there. There'll be a review of the staff report from April. There'll be a report that sort of summarizes the recent decisions that were made at the end of August. There's also a link, it's a little bit different color, but any of the public comments that were submitted on the initial report will also be found. You can read those as well if you'd like to, but there are also public comments. Our report is contained within a larger report for the Finance Commission and the other two agencies in this building. So the primary issue related to the pawnshop employees is issue 3. If you don't want to read the entire report, you're looking for issue 3. There's some more items related to our agency in issue 1 about continuing us, and issue 5 about some general practices, complaints and licensing and some enforcement issues. But 3 is where the issue on pawnshop employee is.
And my understanding of the reason for that recommendation is to reduce the regulatory burden on both pawnshop employees and pawnshop. It allows the employees to quickly get to work without the burden of pawnshop to employ people, but it does also require the pawnshop to take responsibility.
Yeah, there was some concern about whether or not that logic really carries through, and I've heard this from some of the legislative members, Sunset members as well, about actually reducing the scrutiny over Pawnshop employees, and so that is that may be part of the conversation as well.
I mean, this is an example. That comes about the monitoring policy that we have in place that you guys have to get reviewed.
I don't know that I agree with that statement.
The commissioner believes, obviously, that could still be. I mean,
We'll see. We'll see. That's premature for us to speculate on that right now. So.
Okay. Any other questions? All right. Well, I guess we have another question slide. But to kind of conclude the meeting, just on the timeline again for these rules, we're accepting informal pre-comments until 5 p.m. tomorrow, September 28th. You can, again, email them to rule.comments@occc.texas.gov. We will continue to have rule updates available on our website. We'll also be posting the audio of this meeting as well. And we certainly do thank everyone for their participation and bringing your questions and comments so we can improve this draft. You know, we always are working toward getting the best proposals before the commission, and we appreciate our online folks as well, and hope that this has been helpful, and we'll try to clarify the rules further. Commissioner, anything else?
Nothing else. Thank you all. Appreciate it.